The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. This case is State versus McLymore. Justice Berger is recused on this case. We'll hear from the appellant.
Good morning, Your Honors. May it please the court, my name is Sterling Rozier with the Office of the Appellate Defender. I represent Mr. McLymore. I'd like to reserve 5 minutes of my time for rebuttal, please. Your Honors, the fundamental question in this case is as simple as it is important. Does North Carolina still recognize common law self-defense? The answer is clear that it does. When the General Assembly enacted the relevant statutes in 2011, they did so to create a set of enhanced protections, not to abrogate common law self-defense. And the state's argument otherwise is unavailing, inconsistent at times, and frankly leads to absurd results. And the fundamental absurdity in this case is that in 2010 and for decades prior to that, a person in Mr. McLymore's situation would have been entitled to act in self-defense or in defense of another. And the state now wants to deprive him of that right by using a hyper-literal interpretation of a statute to replace decades of common law self-defense and to limit the use of defensive force when the General Assembly sought to expand it by enacting the statutes. And as I see it, we can resolve that absurdity here in at least two ways. First, this court can inform the lower courts that common law self-defense remains available. And second, if this court were to hold that common law defense no longer exists, this court can address Crump and the application of the felony bar. I'm going to begin by focusing on the common law. This court has long recognized that self-defense is the first law of nature, a primary impulse that's an inherent right of all human beings. And as I said earlier, prior to 2011, self-defense was almost entirely a creature of the common law. When the General Assembly enacted the legislation at issue, 14-51.2, 3, and 4, they did so to create enhanced statutory rights to defensive force. They carried with them additional protections and presumptions above and beyond what was afforded defendants at common law. The state has even recognized this in its brief, where they describe the, quote, broader protections of sections 1451.2 and 51.3. And these broader protections do come with a limit. You're not entitled to them in certain circumstances, but that limitation comes from, including the felony bar relevant to this case, they come from section 1451.4, which it's important to recognize that by its own clear and unquestionable terms, 51.4 applies only to the statutory justifications provided in sections 51.2 and 51.3. There's no reasonable reading of 14-51.4 which would make the felony bar applicable to common law self-defense. And while it's true that legislating with respect to an area of common law is a possible indicator that the General Assembly intended to abrogate the common law, that's not a hard and fast rule, and it isn't the end of the inquiry. First, the language of the statutes is themselves clear that the common law still exists. And it matters more what the language of the statute says than the mere fact that there is a statute that was created. Section 51.2G says that it is not intended to repeal or limit any other defense that may exist under common law. And if sections 51.2 and 3 abrogated the common law entirely and provided the only times a person may use defensive force in our state, there would be no common law defense for section 14-51.2G to refer to. Likewise, the explicit reference to the statutory provisions in section 14-51.4 is indicative that there is a difference between the statutes and the common law, and that the common law still exists.
What do you make of the absence? I mean, I understand the argument about 51.2, 51.2G, and 51.4, but what do we make of the fact that there's nothing like subsection G in 51.3?
I think, first of all, we have to read all of these statutes together because they were all created as a part of the same act. And what common law defense, would 51.2G be referring to if not regular common law self-defense? There are instances where defenses that
the statutory section is titled something, I don't have it right in front of me, but it's something like defensive habitation and places of employment, motorhome, that kind of, motor vehicle, that kind of thing.
Right, and there are situations, I think, where somebody may be entitled to that statutory defense, but at common law they would have been limited to common law self-defense. I think defending a motor vehicle, for example, I think that would be just a regular claim of self-defense under the common law. And so if for some reason they were barred from exercising the statutory defense under 51.2, and wanting to claim self-defense, the statute would be read to limit their common law defenses, right? In that situation, if they were barred from claiming self-defense under.
And I guess my broader question, Mr. Rozier, is if we accept your argument and we wind up with a statutory set of defenses and a coincident common law set of defenses with both of them being fully in effect, how is the trial court supposed to administer that system?
I think it would be sort of the way that things have been going. I mean, if we recognize the statutory provisions as enhanced protections that are available sort of in certain situations where they apply, well, then it's appropriate to give the relevant sort of statutory provisions. But if they don't apply, then
for example, if you've got a set of circumstances in which both the statutory and the common law defenses might theoretically be available, is the trial court supposed to instruct separately on both defenses?
That certainly would be one way to resolve it. I think there may be a way to construct the jury instructions so that they instruct sort of as to the common law, and then where the extra benefits of the statutes would apply, they're sort of added on to that. But I think that while there may be a sort of task here for the courts to figure out how to apply these instructions together, that doesn't change the fact that it is improper not to. The difficulty inherent here is nothing compared to the injustice of not allowing people to act in self-defense because of this sort of misapplication and misreading of the statutes.
To use some current popular parlance, is it a zero tolerance policy that's been enacted by the legislature that a felon cannot possess a firearm?
I think so, except for in situations where this court has already recognized where the justification defense would apply under Mercer. But unfortunately, I haven't studied that, so I'm not sure if there are any other exceptions to that. But I think when you have a necessity or a defense or a justification for that criminal act, obviously that would be allowed. But I think that the legislature sort of intended that this always apply.
Well, taking arguendo, what you believe is the only set of circumstances under which a felon can possess a firearm, are you saying that this case flies in the face of that, or that this case endorses that exception?
Your Honor, I think that I'm not exactly sure how this case affects when a person is entitled to possess a firearm as a felon, other than, as we've argued in our brief, when a justification defense would be appropriate, a person would be entitled. But the issue we're dealing with here is whether a person's wrongful possession of a firearm, their felonious possession of a firearm, should be held to bar their act of self-defense or defense of another, regardless of whether there's any connection between their felonious possession of that firearm and the circumstances that give rise to the need to use defensive force. And because possession of a firearm by a felon wasn't actually charged in this case, I think it sort of produces some of the more unusual kind of issues that are present here. I think that perhaps, a justification instruction wasn't requested because that wasn't charged here. There was no real awareness, I think, that needed to be defended against at this point until it arose during the charge conference as a bar to the self-defense. I'm not sure if I answered your question. Feel free to get me back onto it if you like. But I would just want to point out, Justice Ervin, I think I believe something you were asking, to the extent that there is any ambiguity in whether the common law remains in these statutes, the rule of lenity compels the conclusion that the common law still remains as to self-defense. And there are several decisions of our appellate court since 2011 that continue to recognize and apply common law principles. And I think another way to look at this is, we know what the statutes say, but let's see what they do and what is the state's position. And despite the indications of common law self-defense that exists in our state, or that continues to exist, the state and the lower court assert that it doesn't. And I have to anticipate the state's argument a little bit going first, but I've been watching their last several arguments on self-defense, and I've read their brief here, and I think that they're going to assert that 51.3A1 is identical to common law self-defense. I believe they said that earlier today.
That was a question I was going to ask you anyway, so that even if they don't make that argument, I was going to ask you to comment on it.
Great.
With the exception of the language, quote, and does not have a duty to retreat in any place he or she has the lawful right to be. Accepting that phrase, tell me what you believe the difference between statutory self-defense and common law self-defense as it's been recognized in this jurisdiction would be.
That's a big one. The no duty to retreat, which this court has discussed in State v. Pearson in 1975 and McCombs in 79 and Lee more recently. I think there's also there's the 51.3 removes the penalty for excessive force. And I think that issue here.
Right. I may have sorry to let you get past me for a second. When you say the penalty for excessive force, what do you mean? Under section 51.3, there's no reduction to imperfect self-defense when a person uses excessive force. The way I read the statutes, there's no, the statutes focus on the reasonable belief that the defendant has, and there's no sort of question about the reasonableness of the force that was actually used. That there's no question of whether a person used more force than is reasonably necessary to protect themselves. And Your Honor, that ties back into the issue with what I think is present in the state's argument, because I have heard them argue in the past that the common law defenses like imperfect self-defense still remain. So perfect self-defense is governed solely by the statute, and common law defenses such as imperfect self-defense remain. Just last week in State v. Williams at the Court of Appeals in COA 2633, the state argued in a murder case that common law defenses do survive. In this particular case, he can still assert imperfect defense of others. And that was at minute 49 of the video that's available online. And last year in Crump, the state argued whatever's left of the common law is still available for people in these situations. If they kill someone, they can have imperfect self-defense. And that was at minute 59 and 50 seconds approximately of the video. And I'd ask that you take judicial notice of those arguments because we've already addressed why I think that it's incorrect to say that the statute's identical to the common law. But there's also that interpretation would lead to absurd results. Because if 51.3A1, 1451.3A1 is the same as common law self-defense, and therefore any claim of self-defense has to be brought under that statute, but imperfect self-defense is still available, we wind up in some unusual situations, because imperfect self-defense at common law is what you got when you either used excessive force or were the aggressor.
So if you imagine a person who was previously convicted of a felony and they unlawfully possess a firearm, and I'm not saying that they should be allowed to do that, but this is our character here. He's out one day and he sees a man violently beating a woman to the point where all bystanders think the man's going to kill the woman. And he watches several people try to pull the attacker off, and nothing works. But everybody thinks that something needs to be done. So our hero here pulls out his gun and he shoots the attacker and he saves the woman's life. And he wasn't the aggressor. He didn't use excessive force. He had a reasonable belief. So his claim would be for perfect defense of another. And according to the state, our hero is not entitled to perfect defense of another because he's limited to a claim under 51.3, and that's barred by 14-51.4. Therefore, he has no defense available whatsoever. I mean, in fact, under the state's interpretation, our hero here isn't even allowed to punch the attacker to stop the attack, because regardless of whether he uses the gun.
That was actually another question I was going to ask you, Mr. Rozier. I mean, my read of the statute, my read of 14-51.41 is that it includes any defensive force, regardless of whether we're using deadly force or not. Do you read the statute that way?
I think that, yeah, the literal application of that statute here is exactly that. And that contributes to the absurdity.
If I'm a firearm, I'm a felon, in possession of a felon in possession of a firearm, and somebody assaults me, I am prohibited from using any force whatsoever to defend myself, in your view?
Yes, Your Honor. And to put it bluntly, the state would tell you that you just need to die, and if you're being attacked in that way and you're a felon in possession of a firearm, that's it. Just lay down and let it happen. There's nothing you can do. But if we change the facts in the hypothetical y'all were gracious enough to follow me through here, if our hero used excessive force, then the state would say that he's entitled to imperfect self-defense. And this is what is absurd, because someone who doesn't use excessive force and acts, perfectly in defense of another, they have no defense whatsoever. But if they use excessive force, the state would contend that they still have imperfect self-defense. So essentially, we're telling people, if you're committing a felony and you happen to find yourself in a situation where you need to use defensive force, make sure you use it excessively, because that's the only way you'll get any defense. And this can't be what the General Assembly intended. It makes much more sense to conclude that these statutory protections provide enhanced protections for people where they apply, and that the common law still exists as a baseline for everyone. And
does it make more sense to do that, or does it make more sense to construe the statute in such a way as to avoid absurd results?
Your Honor, I think either one of those would solve the problem that exists here. I think that the common law still exists, and for the reasons that I've stated here and in the brief, I think that is the most sort of correct understanding. But certainly construing the statutes in another way, dealing with the Crump issue is the other way to do that. And just to finish up briefly on the common law, we have these two competing interpretations of the statutes, and ours recognizes that the statutes suggest that the common law still exists. It recognizes that the defenses provided at common law and at the statute and under the statutes are different. It's in line with the cases that continue to recognize the common law, and it would allow people like Mr. McLymore to get the same basic common law self-defense instruction that they would have been entitled to in 2010 and for decades before then. And it's important, I think, to remember when we're thinking about all of these questions, that in 2010, if the jury had believed Mr. McLymore, he would have been innocent of any wrongdoing as to his use of defensive force. But in 2011, under the state's interpretation of the statute, he's a murderer. And the only difference is that he was committing this unrelated felony. And that is what is so wrong about the way these statutes are being interpreted and what the state is arguing for. And the state's interpretation.
I think, again, to not to put words in Mr. Sneed's mouth, because he can choose his own words, but At some point, however, the General Assembly's got the authority to modify the common law.
They do, but Your Honor, I mean, again,
So that the mere fact that the outcome in a particular case changes as a result of a legislative enactment, that by itself doesn't really say anything one way or the other, does it?
no, but that's why you have to look at the results and the applications. I mean, we're not talking about someone, sort of changing one element, lowering a classification of an offense sort of by one level or another. We're talking about considering someone whose act was identical.
Hypothetically, could the legislature pass a statute which essentially eliminated the defense of self-defense?
Your Honor, I don't think so. I think there we'd run into some constitutional problems, and I think that it's a little bit sort of interesting to even ask that question when I think we all agree, even the state has said that what they were trying to do when they passed the Castle Doctrine and the Stand Your Ground statute was to enhance the protections provided by self-defense. I mean, I believe that their intent here was not to do away with the defense entirely. But Your Honor, when you're asking, can't they just don't they have the authority to do this? I think it's important to remember, again, as I said, they are enhancing Mr. McLymore's punishment for his use of defense from no punishment at all because he would be free from any responsibility to he's guilty of murder based on no change in the circumstances related to his use of defensive force. The only thing that changed is that they've decided that this unrelated felony should now mean that he just has to die when he's met with deadly force in this way. And so the elevation of this punishment, I mean, it does a couple of things. I mean, at first it removes his right to self-defense it has nothing to do with whether he had a reasonable belief that he needed to act in self-defense, with whether he used excessive force or was the aggressor. None of that changes. It's only because of this other felony. And so in a way, it's sort of enhancing the punishment for being a felon in possession of a firearm to a life in prison sentence. And neither of those things seem like they're reasonably what the General Assembly would have wanted to do, nor are they just. I mean, they are absurd, and they're absurd in the way that the court faced in Holloman, right? The General Assembly couldn't have possibly meant for gunfights to just break out all over the place and people to be free to do that. And it's a similar situation here. They can't have meant to tell felons, people who are committing a felony, that you just have to die if someone attacks you. You can't do anything. But in the event, Your Honor, as you said, if you hold.
Sorry. Let me respond to that. Blank. Let me respond or get you to respond to if this felon had not possessed this weapon, he clearly couldn't have shot the victim here, right?
That's correct.
So let's say the General Assembly decided that the big problem was the use of firearms by felons. Could the General Assembly say we're not going to allow the use of a firearm in self-defense by a felon?
I think they could do that, and I would expect our office and others to litigate that thoroughly if they did it, but that's not what they did here. And I think it's also important to remember the broader consequences of this decision, because Mr. McLymore, we're dealing with possession of a firearm by a felon, but this also applies for any felony, right? If you had somebody who had a little bit of cocaine in his pocket while he was going out to a party and he needed to use defensive force or save someone, that person would be barred from acting in self-defense. And we describe in our brief numerous examples where that happens. And I know I'm rapidly running out of time. I apologize. I want to point out that The issue with Crump is that if there is no common law self-defense and we are limited to the statute, there must be a causal nexus between the felonious conduct and the circumstances giving rise to the need to use defensive force. Because without it, the results are absurd. Without it, we're telling people to just die, like I've said. I think one great example of it is Coley, a man who's committed a felony. He's in a wheelchair recovering from a broken leg. He's got a gun hidden nearby for protection. Someone comes into his house and starts violently beating him to the point where he reasonably fears for his life. Without a causal nexus, we're telling that man to just die. And this court held that he was entitled to the defenses under the statute, despite his possession of a felon by a firearm. I mean, it shows the absurdity. And these are real cases that are happening before our courts. They're not mere hypotheticals. Your Honor, since I'm out of time, or into my rebuttal time, I'd like to reserve the remainder of what I have for rebuttal unless there are further questions.
Thank you, counsel. We'll hear from the appellee.
Chief Justices, of the North Carolina Supreme Court. My name is Mark Sneed, and I'm here with the North Carolina Department of Justice, and I'm here on behalf of the state. I want to boil this issue down into just one basic statement that kind of puts everything in perspective for you, I hope. If this court were to do what the defendant appellant is asking, then basically what you're doing is eviscerating the felony limitation that is found in 14-54.1. All any felon would basically have to do is say that I'm going forward under the common law, and this statute is rendered meaningless. And in essence, it becomes just useless surplusage. I would submit that in order to get a clear understanding of what this statute actually means, it's necessary to just go ahead and look at the plain language of the statute. Statutory construction says basically that if you have a statute that is clear, it's unambiguous, and it expresses a clear thought, then there is no need to go behind the statute and do anything further. The plain meaning should control. And that's exactly what the court did in the Crump case. What we've got here in Crump is the court actually looked at 14. I'm going to refer to them in shorthand as point 1, 2, 3, and 4. They looked at point 4. They looked at the exact plain language of the statute, and the court basically looked at the fact that there was no need for a causal nexus there. They basically said that if the legislature wanted to insert a causal nexus, then they would have done so because they had that option. And recognizing that there was no causal nexus, the court actually acknowledged that the statute for 4.1 was clear and unambiguous, and there was no need to go behind the statute to read anything into it. The only qualification in 4.1 is that the person is contemporaneously engaged in felonious conduct. And the Court of Appeals concluded in Crump that it would actually frustrate the will of the legislature to require any sort of a causal nexus here. And also,
Mr. Sneed, do you read the exclusion in 51.41 to preclude the use of any and all defensive force in the way that Mr. Rozier does? If that person is committing a felony, even if it's a possessory or status offense?
I don't believe that it precludes all. I'm sorry. Can you repeat the question, Mr.?
The statute basically says that you don't have a right to use the justification set forth in 51.2 and 51.3 if you are engaged in the commission of a felony. The state has argued that commission of a felony includes possessory offenses and such as possession of a firearm, possession of cocaine. It also includes status offenses to the extent that there are any at this point, because those are you're committing a felony by virtue of just being in existence at that point. The statute, at least as I read it, says that you're not entitled to use defensive force, which would include both deadly and non-deadly force, I think. And so the question I've got is, is that a correct reading of the statute? Are you precluded from using any type of defensive force, even if it doesn't involve the use of deadly force, if you are subject to the literal language of 51.41?
Well, Your Honor, I believe that we're most likely dealing with deadly force here.
I'm sorry.
We're most likely dealing with deadly force here, Your Honor.
I understand that, but I mean, in order to interpret the statute, I think one of the things we have to do is consider what the ramifications of the interpretation that we adopt might be in order to determine what the legislature might have intended by using the words that it used. So I think we can talk about various and sundry hypotheticals. It might be appropriate to say that that's an outlandish hypothetical and we don't need to worry about it, but at least let's talk a little bit about what the potential ramifications of all interpretations of these statutes might be.
Sure. And Your Honor, I would still contend that you want to look at the plain language of the statute as it's written. And I believe that we have a clear and unambiguous statute that is here. And therefore, because it's clear and unambiguous, there's no need to engage in hypotheticals as Mr. Rozier has done. We have a clear, unambiguous statute, and therefore we just follow the plain language. And looking at
so while we're looking at the clear and unambiguous language of the statute, I mean, the court has had a number of occasions in recent years to try to interpret the statute, and it seems to be an ongoing process. So here we've got another one. What is the effect of 14-51.2G, which refers to the lack of any intent to quote repeal or limit any other defense that may exist under the common law? What do you think the legislature intended by that, by including that subsection in 14-51.2?
Certainly, Justice Ervin. And so what I believe the legislature intended by that particular provision is that 2G just applies to 51.2.
So how do we, so I mean, you know, and I understand that's your reading, but what defenses might we be talking about? How do we apply that exclusion or exception given the remaining language of the statute?
So if we're looking at 51.2 G and 51.3, you're looking at two different statutes. Point 4 basically refers to both 2 and 3. And so when we look at point 3, which deals with castle doctrine,
I'm sorry, I may not be asking my question very, very well. I understand the state's argument that the subsection G does not apply to 14-51.3. But reading it in the context of 14-51.2, which talks about defensive habitation, place of employment, motor vehicle, that type of thing. What does that language mean in the context of that statute?
So I believe that if you're looking at point 3, that's basically a codification of common law. And so because it's codification to common law, you have some overlap there. And so basically, point 2 basically pertains to self-defense. In the instant case, the Court of Appeals actually found that, as we have argued, that 51.2G only applies to 51.2. They actually said that if they wanted to include a limitation on it, 51.4, they could have. But because the two differ, 51.2 is different from the common law, it was necessary for the legislature to include the provision specifying this section doesn't repeal or limit the common law defenses. So the common law defenses
Let's say hypothetically, and I'll be the first to confess I can't give you an example. But, let's say hypothetically that there was some common law defense that would be applicable in a situation in which somebody claims to be protecting their home, workplace, or motor vehicle. How would that, are you saying in effect that we just put the statute aside if the defendant chose to invoke that other defense and go with what the common law rule was?
If he's trying to invoke a self-defense under point 2, defensive habitation,
Yes. Yes.
Okay. And so if he is trying to invoke a .2, the common law remedy is still there. I believe that the legislature intended that. But then that would take you to .4. And I believe that the disqualifier would also apply to any sort of common law defense as well. Because I would argue that .4 argues it applies to both the common law as well as the statutory law. Like I said, if you
So in your view, the exclusion for common law defenses in subsection G is subject to and overridden by the exclusions in 51.4?
Yes, because I believe 2G only applies to 51.2. .4, and that provision is just limited to 51.2. And so there would be no reason to have a similar provision in 51.3 because 51.3 basically codifies the common law, whereas 51.2 is something different. And so basically it would be redundant to put it in 51.3 because it is a common law. 51.2 is something different, so they put a similar provision in.
What do you make of Mr. Razier's argument that if you look at 51.3, it does away with the doctrine of imperfect self-defense?
Doing away with the doctrine of imperfect self-defense.
He argued, if I understood him correctly, that there's no reference to the doctrine of imperfect self-defense or the use of excessive force, and therefore that if you read the statute literally and treat it as exclusive, those concepts are no longer part of our law. I think that's what he argued. He can, of course, correct me the time he's got for rebuttal if he chooses to.
Well, Your Honor, like I said, prior to 2011, the common law exclusively governed the law of self-defense. And I believe that 51.3 is also a codification of the common law. So I don't believe 51.3 changes the common law at all. So in light of that there is no change in the common law for 51.3, I would say that imperfect self-defense is still a viable common law remedy because nobody's taken that away.
If it doesn't change the common law, but it's exclusive, why would it make any sense to enact the statute? I mean, I'm just trying to figure out what all these things mean because, we
Why would it make sense?
see repeated cases come up under this statute, and we wind up having to interpret it, and I'd like to try to do the best job I can at properly interpreting it.
Certainly. Now, when you say the statute, you talked about 2, 3, and 4. And
in this case, I was talking about 51.3. I'm sorry. I apologize for my lack of specificity.
No, that's okay. So I think that they would do that just to basically codify what the common law is. And what you see in all of these statutes is you basically do see a broadening of the common law here. And so in addition to codifying what the common law is, you also see some additions being made to it. Like in 51.3, in 51.2, you've added some presumptions where you're presumed to be in fear of life if somebody comes into your house. You also are presumed to you're presumed to be able to use that. You're presumed that anybody that comes into your house has the intent to use deadly force. Point 3 is basically it just codifies the stand your ground law, which has been the law forever.
I just want to ask you about going back to this question of what we're to make of 51.2G.
Yes, ma'am.
It seems to me it's got to apply to 51.3 because 51.3 incorporates 51.2. It says that a person is justified in the use of deadly force and does not have a duty to retreat, et cetera, under the circumstances permitted pursuant to 51.2. So don't we have to include 51.2 in our interpretation of 51.3?
I don't believe so, because like I said, 51.3 codifies the common law. 51.2 differs from the common law, and that the legislature decided to codify the defensive habitation. And so because 51.2 differs from the common law, it was necessary for the legislature to include a provision specifying that the section does not, in fact, repeal or limit the common law defenses. So that's why you have a difference there.
Right, but my point is that 51.3 incorporates 51.2.
I would see them as being different because you're dealing with 51.3. You're basically codifying the common law of stand your ground, which has been the law ever since. It's been exclusively governed by the common law. 51.2 is more so a product of legislation. So I'd say that they're two different things.
But in interpreting 51.3 and deciding when a person is justified in the use of deadly force and doesn't have a duty to retreat, we have to apply 51.2.
I would see them as being completely different. 51.3 and 51.2 are completely different. I would say that 51.2 governs exclusively the defensive habitation, and I would argue that 51.3 is exclusively the stand your ground law. So two different situations. One is governed by the common law, whereas the other is a creature of statute.
Okay, but then you are saying then that 51.4 with the exclusion of anyone attempting to commit or escaping after committing a felony, that's new.
That is new. So basically, when you look at 51.4 and you look at the common law of self-defense or the law of self-defense generally, so self-defense generally will take a dim view of actors who have unclean hands, so to speak. For example, you have the doctrine of the aggressor. If you have somebody who is initially an aggressor and who is forced to eventually take up some sort of defensive force, then generally the law is going to look down upon that and basically say that we're not going to give you, as the aggressor, a bad actor, the benefit of using self-defense. And so basically what 51.4 does, it kind of extends that sort of view of the common law. And so when you look at it and you say that, well, this person's a felon, he's a bad actor, and because he's a bad actor, the legislature has made the decision not to give this individual the benefit of self-defense. I know Mr. Rozier has come up with a number of results that on their face seem absurd. And I mean, no law is going to be perfect. And he relies on the Coley case as kind of his justification for going behind the statute and doing something different. Whereas Coley can be completely distinguished from the situation here. In Coley, the issue there was the prosecution never even asked for an instruction under 14-51.4. And so he was afforded a self-defense instruction. So had the defendant or had the state asked for an instruction under 14-51.4, I believe he would have gotten it. But I don't believe that we can use a case like Coley to say that that we should give a self-defense instruction in cases like this, because 14-51.4 was never even addressed in Coley.
While acknowledging opposing counsel's identification of what he terms absurd results, and you saying in response just now that no law is perfect, are you acknowledging that, as you had said earlier, the statute speaks for itself, that there will be absurd results and this just has to be accepted as part of that process?
No, sir, I'm not saying that there will be absurd results, but I think that if you think if you have time to think, there, it's easy under almost any law, not just this one, to think of how you could have absurd results under almost any context. And so in that regard, I'm saying that this law is no different from many others. Many of the examples that opposing counsel used, they're stretches. They can't, I mean, no law is going to be perfect, but I'm not saying that the way this law is written invites absurd results. I believe that the will of the legislature was to basically limit self-defense to those who were law-abiding people. If you look at other areas of the statute, it also grants further kind of protections to people who are law-abiding citizens. For example, it expands the defense of habitation to include the curtilage. It also has presumptions about somebody coming into your house with the intent to use deadly force, or it also presumes that somebody who is in a house, basically, they are in, like, it's reasonable for them to believe that the person coming into their house is going to use deadly force. So it kind of cuts both ways here. It's expanding the common law by giving some benefits to law-abiding citizens, while it also tries to somewhat take away justifications for offenders. I shouldn't say offenders, but bad actors, so to speak.
Justice Irvin did say earlier, and indeed it's a correct recognition, that we have to, as a court, look at these statutes in such a way that there's going to be obviously other times when circumstances arise and we've got to give trial courts proper direction. How would you see this court interpreting the statutes that are at issue in light of this current case going forward, in terms of, on one hand, upholding what the legislature would intend, but on the other hand, upholding what you recognize as being still the existence of common law self-defense being recognized?
In this particular instance, Justice Morgan, I would argue that this court should just take the plain language of the statute and just follow it itself, because we have other statutes throughout our laws that also punish felons. For example, felons have enhanced sentencing. Felons cannot possess a firearm. They can't hold office. They can't sit on a jury. And there are many, many other cases where felons, their behavior kind of takes away privileges that other people would have. And I believe it's the intent of the legislature to kind of extend that principle to this job, or to this particular statute. And because it's been the legislative intent to do that, and I think if you look at the statute, read the statutes together, point 2, point 3, and point 4, then I think that basically shows the intent of the legislature, that they want to reward law-abiding citizens, and they want to basically discourage bad actors, as we have as the felony disqualifier seeks to do.
Does it make a difference here in the present case that the offense of possession of firearm by a felon was not charged?
I don't believe so, Your Honor, because it wasn't charged. And so defendant didn't have to, he wasn't facing any sort of punishment for possession of a firearm by the felon. But if you look at the record, I believe it's on page 1099 of the transcript, the defendant admits to being a felon. If you just look at the quality evidence, there's really no doubt that he possessed a firearm. They discussed the charges at the charge conference, and nobody ever, I guess defense counsel never asked for any sort of instruction on I guess possession of a firearm by a felon, which I guess would be justification or anything like that. In this particular case, Your Honor, I would argue that this defendant would not have been entitled to an instruction on justification anyway. That being because case law basically says that a justification defense is only going to be given out in very narrow and very limited circumstances. Also, if you look at the Craig case basically says that anybody who is charged with possession of firearm by a felon, and it can be shown that this particular defendant had a firearm prior to the possession, whatever the murder, then, or the time that gave rise to the use of force, then they're going to be disqualified from it. So basically Craig, he would not have been entitled to a justification defense anyway, based on the evidence of record.
So I just want to make sure I understand your position with regard to the intent of the General Assembly in 51.4, saying that the justifications described previously in the statute don't apply. Your position is, even if the individual had committed a felony years ago, had a rifle in their home that was not loaded and didn't work, but if someone comes into their home and attacks them, they don't have the right to defend themselves.
So I'm listening to your hypothetical, Justice Earls. And so in your hypothetical, did you say the rifle was unloaded?
Right. They're still possessing a firearm. It's not loaded. It doesn't work. They can't use it, but it's still a firearm and they're in possession of it.
Again, I think I would still have to look at the plain language of it. That's just it's kind of a situational kind of a basis. I mean, I get it, but I believe that the will of the legislature kind of has to be upheld based on the way that they've written it. And I can actually say that the legislature looked at a number of different statutory schemes and tried to draft their felony disqualifier. And actually, one of the very early drafts of the statute actually had a provision in it that basically had a causal nexus or anything like that. They chose to reject it in favor of this particular scheme.
But I will say, so I agree with you. We have to look at their actual language. And it seems that the attempting to commit, committing, or escaping after the commission, all is very active language. It suggests they are in the act and not the passive kind of, Justice Ervin talked about status felonies, possibly, I suppose, being a habitual felon, but, this language seems to me to be very active. They are in the act of committing a felony, not sort of passively in a condition that has no relationship to what led to the need to use force. So can't we look to the language that the legislature actually used and understand that they're using very active language, that someone needs to be sort of affirmatively acting in a way that's committing a felony?
So, like, under your hypothetical, are you saying that basically the person who just has a gun in their home that's unloaded, but they need to use some sort of defensive force, then you're asking me because that's passive, that wouldn't survive? Is that your question?
Right. So now I'm just saying, looking at the actual language that the legislature used in this felony disqualifier, that the language here seems to me to suggest an understanding that someone is actively engaged in attempting to committing, or escaping after commission of a crime, not that they are sort of passively possessing cocaine in their pocket or happen to have a gun in their house.
And I think that's one reading of it, Justice Earls. For example, the person who has cocaine in their pocket, that's a very passive sort of a action. It's not really harming anybody. And I would think that the cocaine would have nothing to do with the use of defensive force. So possibly I could see that. And I see my time is running up very quickly too. But I wanted to address basically the constitutional issue as well. And I want to correct the record on this. In my brief, I said that that issue was not raised in the Court of Appeals brief, but it actually was. So I want to correct that for the record. And I want to just kind of briefly address Mississippi v. Chambers. In that case, basically what we have is a defendant who was not allowed to present any sort of testimony that would have allowed an alibi to be put forth in the evidence. That's not what we have here. Basically what we have here is somebody who was a bad actor. He was a felon. And basically this Mr. McLymore was able to put on a full defense. Nobody denied him any sort of witnesses. Nobody denied him any sort of alibi testimony, but he was able to put on his case in full. And so therefore, I would contend that Chambers is inapplicable to this particular situation because Chambers' defendant was not a bad actor. Here we have Mr. McLymore, who's a felon. Mr. McLymore was able to put on his full defense, whereas Mr. Chambers was not. And so for those reasons, I would say that those cases differ, and we don't have any sort of issue with constitutionality in this case. I see it. I've got about 50 seconds, a little less than a minute. I know we've had some very spirited discussion. I'm happy to answer anything else with my remaining time.
Thank you, counsel. We'll hear rebuttal.
I may have misheard, but I think that I heard the state suggest that being engaged in a passive felony such as possessing cocaine may not have anything to do with the nature, the need to use defensive force, and under a reading of the statute that reads the statute as using active language, that would maybe not trigger the felony bar. And to the extent that I'm correct in hearing them having said that, I wholeheartedly agree, because that's a causal nexus. That's the causal nexus that we're asking for, that be required, that the felony offense have something to do with the circumstances giving rise to the need to use defensive force. First of all, further, I want to.
What if it just has to do with how the defense was carried out? I mean, this is not a situation where he had a gun in his pocket, but he used a knife or he used his hands. This is a situation where he actually used the gun that he was prohibited from using to kill the victim.
I think that's that sort of doesn't really address the fact that if he's justified in acting in self-defense, it's not appropriate to limit him in any way. I mean, the fact that I think the plain language of the statutes does say that if you are committing any felony whatsoever, you're not entitled to use any defensive force. Or at least the defensive force that's set forth by statute, sort of gets at that. But I wanted to point out one thing that the state said was that he was not punished for possession of a firearm by a felon, and I agree that he was not charged with it, but he received a life sentence because he was possessing a firearm as a felon here. He was absolutely punished for it, and that is the absurdity that comes from applying the statutes in the way that they are asking to. With respect to the plain language of the statute, to the extent that the statute appears to require an active felony and not a passive felony, I would be happy for this court to read a causal nexus requirement into that. Beyond that, we are looking at the exact same plain language in the statute that this court in Holloman held could not apply unless a prerequisite was read into it. It's the exact same language that this court has already recognized leads to absurd results if it's read as written. And we're asking for the exact same consideration that this court engaged in Holloman. Just there must be a causal nexus present before the felony bar can be held to apply. With respect to the state's position on unclean hands, they've argued that section 51.4 extends that doctrine of unclean hands, but I don't think it extends it. It removes it, because the state argues that we limit self-defense at common law based on fault. But if we limit self-defense under the statute without a causal nexus and with no contribution of the bad act to the need to use defensive force at all, then we're no longer applying unclean hands. We're just preventing people from exercising self-defense for entirely unrelated to the situation that they find themselves in. And I'd also point out that Lee clearly recognized that there was no duty to retreat in the statutes, and that was a difference in the common law. And to the extent that there is any confusion about whether there was a duty to retreat at common law, I think this another way that the statute is different is that it unequivocally removes that confusion. And I think I have blustered through everything I noted down. So if your honors have any more questions, I'm happy to hear them, but otherwise I'll rely on our brief for the remainder of the arguments that we've made. But we ask that this court reverse the Court of Appeals. Thank you.
Thank you, counsel. Thank you to both counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state and this honorable court.
Thank you, everybody.
Thank you.